So we're here today to talk about Proposition 19. I'm calling it the dark side of Proposition 19 for two reasons. One is the massive tax hike that we'll get into, but two is that there's a really looming important deadline coming up that I just think a lot of people are not aware of. So this is an excellent opportunity for us all to become aware, and then certainly something I think that your client should be aware of too, if they're interested in taking advantage of the current law before the new tax line. So let's get into it. So what are we going to do? Well, we're going to talk about what is Proposition 19. In order to do that, we need to have just a little bit of a primer on Prop 13 that hopefully everyone's familiar with. Then we're going to talk about what is, or really what was, Proposition 58 and 193, because that's really what's sort of getting eliminated with the new law. We're going to talk about how Prop 19 affects that. We're going to talk about the deadlines, which are February 15th, but really the 11th we'll talk about. We're going to talk about what to do, or some advice that you or your clients might be interested in hearing. And then time permitting, we will talk about the benefits of Prop 19. I think we'll have time. We got into a little bit of it yesterday because there are some benefits. So let's get right into it. So about me, those of you that don't know, some of you have been part of previous presentations, so I won't spend too much time, but I am a real estate attorney and a real estate broker. I used to actually do litigation, so I was in the courtroom, arguing cases. I did lose a little bit of hair, really stressful, and one day kind of just bright idea, I don't want to do the litigation anymore. I'd much rather do the fun side of real estate. So I actually was a real estate broker already, but then I got more involved in transactional work, forming my own company, and then have affiliated with Villa Real Estate recently. Very happy there. Been a part of the CAR Mediation Center for quite some time. So I'm one of the mediators on the CAR mediation panel. That's a lot of fun because I get to experience, all sorts of interesting disputes and help people work those out. And I've done some presentations on that. Some of you may have seen. And then a little while after that, my wife, Courtney Lucas, who's a CPA, dragged her into the business because we are a married couple in real estate. We are legally required to have the husband and wife photo. So that's our little team. So, okay, introduction. What is Proposition 19? I'm not going to sugarcoat it. Proposition 19 is a gigantic tax hike. It is a huge tax hike that is going to affect everyone in our coastal markets, and is certainly going to impact the next generation of property owners that we're going to get into. So what is Proposition 19? Well, I view it as a massive tax hike on family transfers, which is essentially taking away Proposition 58 and 193 that we'll get into in a little bit. It does provide some new or really expanded benefits to 55 and older and disaster victims, allowing you to essentially relocate anywhere in the state, and even for a more expensive property. So we'll get into that. We will talk about some of the good, but to me, the bad is more important, and it's coming up soon. It's coming up real soon. In fact, it's starting February 16th, 2021. So that's what, 2 months away and change. If you transfer your property to your children or to the grandchildren if the parents are dead, they will, via any means, it could be a gift, a sale, a hybrid, an estate plan after your passing. We'll get into some of those options. That property is going to get reassessed to full, fair market value. No longer will your children or your grandchildren inherit your Prop 13 basis, as had been California law for nearly 25 years. It is going to be gone come February 16th. There will be a limited exception to primary residences that are owner occupied by both the parent and then the child under $1 million in fair market value. We'll get into that. But this just absolutely revokes the longstanding benefits of Propositions 58 and 193, which were overwhelmingly passed back in 1986 and 1996. So these have been around for a long time. Proposition 13, Proposition 58, Proposition 193, collectively, they saved people a whole lot of money in property taxes, and those are just gone. So that is, the short story. I view this as nothing shy of a death tax and an inheritance tax on real estate. That's what it is. Areas with the highest property values, such as Newport Beach, Laguna Beach, some of our coastal markets here, the areas that you all serve are going to be most impacted by this issue. In fact, for the Legislative Analyst's Office, California's next generation of property owners will be taxed to the tune of hundreds, that's plural, hundreds of millions of dollars a year. That's the impartial legislative analysis. If you talk to groups such as the Howard Jarvis Taxpayer Association, they peg that figure as a billions with a B. That's billions of dollars a year in additional property taxes, thanks to Prop 19. Okay, so what's going on? Well, to understand it a little bit, we need to just take a little bit look back at Prop 13. I think some of you are familiar. Some of you may have been around in the 1970s. Some of you, bless you, may have actually voted for this proposition. But obviously in the 70s, there was a big concern about increasing taxes. People, just like they are today, they were becoming sort of house rich, but cash poor, as you would say. And they passed Proposition 13, which, as we all know or should know, it basically pegs your property tax basis to the value at the time of purchase. Not necessarily the purchase price, but it usually is. If you get a super good deal or something, the county could come back and say, no, you got too good of a deal. I'm going to increase you a little bit. But bottom line, basically, whatever you bought the property for or whatever it was worth at the time you purchased it, that's your property tax base. And it's limited to going up just 2% per year. And as we all know, in some of our coastal markets, properties have certainly appreciated far more than 2% per year. So because of all this, we have nice low property taxes, especially for people that have been owning their homes since the 50s, 60s, and 70s, which I'm sure a whole lot of you have examples of that happening. So what happened later? So after Prop 13 passed, people passed Proposition 58 and 193, which allow for family transfers. And this is still good law until that new law takes effect February 16th. So I think it's very important to talk about it. A lot of people don't really realize, I think, the advantages that are available today and that are going to be shortly going away. So Proposition 58, which was passed in November 1986, it essentially allows a parent or a grandparent, but only if the parent is deceased, or sorry, that's the next one. The Proposition 58 allows the parents to pass the property to the child. If it's your primary residence, there's absolutely no income or limitation on the value of the property. So it could be a $200,000 property, an $800,000 property, an $8 million property. It does not matter under the current law. You get to transfer all of that property tax basis to your children, whether you gift it to them, sell it to them, or give it to them in their estate plan. So right now, there's absolutely no cap on the primary residence. And there is a cap on $1 million of assessed value of all other property. That's an important distinction. It's $1 million of assessed value under the current law. So it doesn't matter if that Newport Beach duplex is worth $4 million. If they bought it back in the 70s for, 80 grand or whatever, and their property tax basis is, a couple hundred grand, under today's law, you can pass that absolutely to your children and get the full property tax benefit passed down. Proposition 193 essentially expanded that into grandparents, but only if the parents are dead. So you've got to have grandparents, you've got to have dead parents, then it can go to the grandchild. But if the parents are still alive, you can't do it. Now, some people do a workaround. You can go grandparents to parents to children. And, in theory, that's a workaround, but you got to trust that middle layer that they won't, sell the property and move off to Vegas. So let's talk about an example. So the parents own a house, but we are in some nice coastal markets. So let's upgrade that a little bit. Parents own a house, and it's a nice house, Newport Beach, wherever it is. They have a family. They start to raise a family one day. Oh, great! I want to leave my property to my children. And there's three basic ways that you can do that. And you can do that alive or at death. You can do it as a gift. You say, hey, here, take the house, raise your kids here. I can't take it with me, so I want to see you enjoy the property while I live. Very common situation. Cash, you can obviously buy it. You can buy your parents' house. People do that all the time. Sometimes it's for fair market value. Sometimes it's below fair market value. And so you can do sort of a hybrid of a purchase and a gift. In fact, that's a great way. If there's an existing mortgage, you could basically buy it, get your own new loan, pay off the mortgage, and then have the property in your own name. And you can use what's called a gift of equity, the delta that's left of the income. It does have to be reported as a gift on a gift tax return, but there's no tax consequences right now for most estates, given the current law. So anyway, they can buy it, or as we see more commonly, people inherit property at death, right? That's sort of the most common outcome. Certainly for our areas, we see that a lot. So again, to recap, we've got a gift, we've got sale, we've got death. Death is really just a gift at a different time, right? But just instead of gifting it while you're alive, you gift it at death. So these are the three main ways that properties pass between parents and children. So just to recap, Proposition 58 would allow the parent to transfer the property to the child, the primary residence that the parents lived in, absolutely no limit on value. And under the current law, there is no requirement whatsoever that the child live there. So the child could take that property and then turn it into a rental property, or they could move in, or they could sell it, do whatever the heck they want. No requirements whatsoever on what happens at this end. But the parents do have to be living in it. It has to be their primary residence. No limit on value to transfer to the children. Big benefit. We'll get into some of the examples later. Then also, as we talked about with the income property, same thing, up to $1 million assessed value. So if you had a family that built up a portfolio a long time ago and gobbled up some of these properties for 10, 20, 30 grand, way back when, their property tax basis might be under 100 grand each. And you could transfer maybe 10 additional investment properties to your children. Again, under the current law, it does not matter what the fair market value of these properties are. All that matters is what is the tax basis. And you can find that out by looking on your tax bill, and it says what the assessed value is for property tax purposes. It's also public record. You can look it up online. You can look up anyone's online, but certainly look up your own if you're going to start doing the math on this. So Proposition 193, as we talked about, exact same rules, except it's grandparents to grandchild, and the parents have to be dead. So, the parents have to be dead for that to work. And sometimes that is a hurdle, because sometimes you get families that are estranged and things like that. And it's unfortunate because it does require the parents to be dead. So that's sort of the current law. Fun little fact, people ask me all the time, what about siblings? No, there is no sibling to sibling transfer. There's not under the current law, there's not under the new law. And that gets people in trouble a lot, right? They inherit a property from mom to the two siblings, and then the siblings say, well, let's buy each other out. That actually would trigger a half reassessment, because once you change the title between the two siblings, that's a change in ownership, and you're only then going to get a 50% benefit and a 50% reassessment. So there are some fun workarounds with that. But that's the big picture. Basically, you could transfer the property from parent to children, get the property tax basis 100% on that regular property, and up to the $1 million on the other one. So let's get into it. Let's take a look at a little example. I've got 6503 Seashore. This is a property actually I sold earlier this year. My wife and I were fortunate to work with the estate. And so I'm going to use this as a great example, and not divulging any confidences. This is all public information that you can all look up. So every single one of you can go into your files, or maybe even you personally, depending on how long you've lived in your home. Every single person on this call has an example like this they can dig up. But this is a great one, because this really shows the benefits of the current law. So good old parents, I believe her name was Dolores and Alvin, I think it was, bought this property back in 1974 for $70,000, right? So good for them. They made a nice, sound investment for their family. They actually did live in the property for a while. Then it became a rental property, and that's what it was used for at the time of their death. So the parents deceased, for our example, we're just going to say they died in 2020, or maybe a little bit earlier. We'll get into that. The 2020 value and what the property ultimately effectively sold for was $2.5 million. So they bought it for 70 grand. It was worth $2.5 million at the time of the inheritance, right? So when the parents died and it got passed, it was worth $2.5 million. So their property tax bill at the time of the inheritance was based on a taxable value of $188,000 and change. So that's the Prop 13, right? So that's that nice low $70,000 purchase price going up the max 2% per year every year. And it totals, $188 and change, which means they had a whopping tax bill of $2,400 and change, about $2,500. So had they kept this property forever as a rental property, or they'd moved into it, under the current law, they would keep that low tax basis forever, as long as they own the property, until there's another non-excluded transfer. So we do the math. So let's look at it. What would happen without Proposition 58, which essentially is what's going to happen come February 16th. So without the Proposition 58, we have the exact same fact pattern, except upon the death, and we're just going to assume that was the value at 2020, it's around when they died, at the time of the death. So the second mom, is dead, that property is going to get reassessed to full fair market value. $2.5 million house, that's going to be a $25,000 annual property tax bill. Significant. Takes effect the second the death happens. I've got a little asterisk there because that's just sort of round numbers. We all know there's some other things on property tax bills, some bonds, some measures, things like that, that add up to it a little bit. But in simplest terms, it's going to go from $25,000 all the way up. So we do the math. Again, under the current Proposition 58, under the current law, their property tax bill would be basically $2,500. Under the new law, or essentially without Proposition 58, their property tax bill would be $25,000. So we're adding a zero here, folks. That's a difference of $22,500 a year forever. So if they kept this house, if this had happened next year, February 16th, after the new laws take effect, they would be paying an additional $22,500 on their property forever. Now, some people might think, okay, no big deal. You can make your arguments for that. That's fine. But here's the annoying example that I think we're going to see a lot of. Sometimes estates don't sell property right away, right? Mom dies. We have a funeral. We have an estate plan. We need to deal with other assets. Maybe it's tenant occupied. And because of rent control, you cannot evict tenants. Maybe you want to remodel the property before you sell it or something like that. Bottom line is that from the day mom dies or dad dies until you sell it, you're getting this higher property tax bill. So in this example, the estate took well over a year to sell the property. It was tenant occupied. So the tenants eventually left, and they did paint, carpet, things like that. But there was a lot of other things going on, right? There's other beneficiaries. There's other things to do. Nobody thinks oh, mom died, let's list the house for sale immediately. No, they take a little bit of time. In this case, it took a while. It took them over a year. So whereas currently today this house is already closed, they basically paid an extra $2,500 to hang on to that property for a year. Under the new law, if this exact same thing had happened next year, that estate would have paid this entire giant property tax bill while holding the property just in the time it took them to sell it. So in this example, if it took a year to sell from the death, that's an extra $22,500 that is taken away from the heirs, taken away from the beneficiaries, away from the family, and given to the state of California. If that's not a death and inheritance tax, I don't know what is. And I understand the arguments for or against it, but the simple fact is, as of next year, this is a gigantic property tax hike for people that are going to fit into this situation, which in our market is quite a few people. So what is Proposition 19? Well, again, in my opinion, it is a gigantic tax hike, probably the largest property tax increase in California history. I mean, this is going to be huge, and we're not going to see the ripple effects of this until a long time, right? Because it doesn't kick in immediately. If you own your home, you've still got Prop 13, your taxes aren't going up. It's all about when you die or when you transfer the property. So we'll start obviously seeing this come next year, but it's going to take, I think, a couple of years for people really to realize, the impacts that this is making. So again, Proposition 58 and 193, they're gone. As of February 16th, they're done. The parent to child transfer in the Prop 58 analysis, we'll talk about what the current rule will be, but the current analysis that we just went through, completely done. As of February 16th, new law takes over. You don't get any of this anymore. Same thing with the grandparents one. There is one exception. So the new law does have an exception, right? And it's got three elements that I think are going to prove challenging for people. Especially sometimes in our market. So first of all, it has to be the primary residence of the parent. That's the same as the old law. So nothing new there. So we have to have the primary residence of the parent. But then these two next stages are brand new. So the value of that primary residence has to be under $1 million in today's market value. So not the assessed value, today's market value. Which $1 million, for those of you that are practicing in some of our coastal areas, we know is not a high threshold. There are markets in Orange County where this is going to affect essentially every single house is going to have at least some sort of partial reassessment. But to avoid the full reassessment, this is the test. You got to have the primary residence of the parents, the value under the million, and then the child must move in and make that house their primary residence within the first year. That is brand new. Remember, under the current law, the children could inherit the house and then just use it as an investment or move into it later, do whatever they want. Under the new law, the child has to move in within a year. I think that's going to be a challenge for a lot of people because a lot of people might not want to move into mom's house, or maybe, they already live out of state or something like that. Who knows? It's not going to be ideal for everybody. But obviously, some people are going to do that, especially to get these tax benefits. They're going to jump right on it. We'll talk about that in just a second. So what happens if it's over $1 million? Well, you get a blended rate for everything above. So you're not going to just get a full reassessment. If it's a $2 million primary residence, you are going to get some benefit for the under $1 million. You'll basically get your sort of existing tax base for the under $1 million. And then you're basically going to have a blended rate, essentially pay taxes on everything over the $1 million. So it's clearly going to be a benefit. But it's nothing like the current benefit, which is unlimited amount of purchase money or of the value of the property, and it doesn't matter what you use it for at the end of the day. So this is a big change that's clearly going to affect a lot of people. So all of these investment properties, all of mom's or grandma's investment portfolio, no, it's out the window because again, the parent had to have lived in it at the time. So there's no more additional $1 million. That's all gone. It had to be the primary residence. So anything that wasn't a primary residence, any sort of rental, any sort of vacation home, any sort of vacant land or whatever, it's just unfortunately not going to work. So that's sort of the big issue. Let me just check something real quick. Very good. So same thing with the house. Well, I kind of said that the house probably isn't going to qualify. Oops. There we go. That the house probably isn't going to qualify just because it's going to be worth over that $1 million. Again, you are going to get some sort of blended rate as long as the parent lives there and then the child moves in eventually as well. So a big question I've been getting asked a lot of, well, how long do I have to live there? You know, can I move into mom's house and move right out? Well, you know, this is going to be a fun one. The law basically very clearly says that you have to make it, well, what it really says is that you have to file the homeowner's exemption on the property within a year. But you peel back the onion on that law, and it basically means you have to make it your primary residence. So, you know, I would definitely be changing my voter registration, you know, changing the DMV, all that kind of stuff. But technically, I don't see anything in the law that says how long you have to do that. So I'm sure we're going to see some people, you know, moving into mom's house and then deciding, you know, this isn't right for me, or the ghost of my mother is haunting me, and I want to move out. So I think we'll see a little bit of that as one of the theoretical little loopholes. But again, you're still going to have that $1 million cap, so there's nothing to do about that. So why did this happen? I think it's important to talk about this. There were two essentially coalitions. If you look up both the Secretary of State website and the Ballotpedia, and I have the sites for all this information on my website that I'll give you the link to when we're done here. But basically, there was a coalition of firefighters, realtors, seniors, disabled homeowners, wildfire victims. And then there was the Yes on 19 tax savings and housing relief for seniors, severely disabled, wildfire victims, sponsored by the California Association of Realtors. Well, that all sounds good, but if we look at the money, we've got about $42 million pouring in to this ballot proposition. We've got about $400,000 against it. Do the math on the disparity of the money that was put into the campaign versus against it. We look at the major donors, California Association of Realtors, $35 million and change, almost $36 million. The National Association of Realtors, $4 million and change, really almost $5 million. Yeah, I guess there was a coalition of firefighters because they put in $100,000. I'm not quite sure what $100,000 into, you know, 40 some odd $1 million is, but, you know, it's a very tiny fraction. And then they did get a labor union to contribute $10,000 as well. So let's be honest, this is the Realtor Association, right? So the CAR and NAR were clearly the backers of this. California is a blue state to begin with, as we know. So, you know, in all honesty, taxing, you know, wealthy homeowners is probably not the hardest thing in the world. We all saw some of the TV commercials that showed, you know, nurses and firefighters and whatever, you know, we need more tax money. And that's sort of the sell. So, you know, we're way beyond schoolhouse rocks nowadays with how bills become laws. You know, call me cynical, whatever you want. But obviously it takes money to do ballot propositions. It takes special interest. It takes the legislature, which helps put it on the ballot. You've got the blue state of California with rising taxes already. And, you know, it's not exactly rocket science to figure out, you know, how this comes about and how we end up with a gigantic tax hike in the state of California. So even with all of that money pouring into it, it's still barely passed 51.11% versus the 48 and change. That is a very thin margin, especially when you look at the amount of money spent. So I think this shows that, you know, some people out there actually did read the bill. Some people out there actually do, you know, have concerns about property rights and you know, aren't in favor of just taxing property owners. But nevertheless, you know, competing with the money and those fancy, fun-looking commercials talking about how we need the money for schools and children and medicine, firefighters, and all that stuff is hard to beat with. So, you know, that's my soapbox on that. But it is the law, and it's going to take, I think, a ballot proposition to undo it. And I don't know if that's going to fly in California, you know, with our kind of current state. So let's get into it and kind of finish this. What's going on? Well, we've got a real deadline. The deadline technically in the law is February 15th, right? The old law lapses on February 15th, but that's very misleading because February 15th is a holiday. That's President's Day. So I think the county recorder's offices, well, I know for a fact the county recorder's offices are going to be closed on that Monday, President's Day. And I'll do you one better. They're going to be closed on the Friday, February 12th because of the President's Day holiday. So in reality, you've got until February 11th to get these things filed. I'm kind of reading this and certainly giving people my opinion that this is a filing date, a transfer date, not necessarily a postmark date, not a date of death, nothing like that, that this is a real filing transfer date. And maybe there'll be some leeway on that, but I'm not counting on it. I got an email from my electronic service provider yesterday at Los Angeles County. Even if you e-file a document in Los Angeles County, they're running 4 to 6 weeks behind right now. So I am going to start getting real nervous about this deadline as people do come to us to facilitate this, which we do, and I'll talk about that in a second. So what to do? Well, I'd be definitely having a conversation with your clients, maybe even your own parents, about considering this transfer before February 11th. So, there's a lot to think about. It's never fun to think about, death and estate planning. And certainly to do it while you're alive, transfer the property is not necessarily everyone's cup of tea. But I think people are definitely going to be looking at that. So let's talk about some of the reasons why you would not transfer the property right now to your children. Well, the biggest example, to be honest, right now we have what's called a step up in basis, the stepped up in basis, the step up basis, call it whatever you want. It's a very favorable tax law that essentially in a roundabout way says it's better to inherit property at death than it is to be given it at life. And I'll try to give a 20-second example there. So going back to my Seashore example where the parents bought it for $70,000, when they died, it was worth $2.5 million. So the IRS for tax purposes basically treats it as if you bought it for $2.5 million. If you then go to sell it for $2.5 million, there's no taxes due, right? Because there's no gain. You bought it for $2.5 million, you sold it for $2.5 million, no taxes due. If you did not have this step up in basis, then you've got that $70,000 number and you sell it for 2.5. Well, shoot, we've just made what? $2.43 million in profit. That's going to have capital gains taxes, which is going to bump you into the 20% federal, 13 and a third state. That's a 33% tax that you'd be paying on this. So this step up in basis is a big deal. But to make it more fun and to add more into the mix for everyone out there considering this, President-elect Joe Biden, it is in the tax plan that he wants to get rid of that. I mean, it is viewed as a giveaway to the wealthy, just like, kind of the current proposition. So, who knows what's going to happen? There's still an election. There's still, control of the legislative branch up for grabs. So, we have no idea what the tax laws are going to hold in the future. But this step up in basis is definitely something that is talked about as wanting to be eliminated by certainly a lot of people in politics who do view it as a benefit to wealthy people. So, I really hate families that, are counting on this, don't do the transfer now, and then something like this goes away in the future. And then you've got a double tax, right? Because you've got the increased property taxes and that. So, that's going to be tough. So we don't know. We don't know what the future is going to hold. An existing loan on the property. This is probably the most common one that we come into a lot, right? So if the parents own the house and they've still got a $400,000 mortgage on it, well, I guarantee you, as we all know, there's a due on sale clause there in that mortgage. So technically, you cannot transfer it to your child without violating that due on sale clause. Practically speaking, do lenders check that? I don't know, but it is a technical violation, and that could be a very bad situation where you transfer the property, the lender finds out about it, the lender basically writes you, says, hey, give me my money back, and then you have to refinance or something like that, which maybe you can do, but maybe you can't. And after February 16th, if you transfer the property back to the parents, then it's going to get reassessed because now you don't have that ability to transfer back and forth anymore. So it is sort of a big problem. So the loan is definitely something you have to think about. Like I said, a lot of people do this then as a purchase. So if you have an existing loan on the property, the parents do, an easy workaround that is the child purchases it. They get their own new loan to basically pay off the parents' loan. And then now they own the house with the loan in their name. And heck, with today's interest rates, you're probably ending up getting a much better interest rate than the mortgage that's currently on there. So a lot of people do this as a purchase. And in fact, depending on how much equity there is in the property, you have a lot of options. I mean, you could potentially, get a lot of cash out. you could actually do it as a legitimate purchase where the parents are getting money. So, okay. Last reason why not, obviously a personal decision. Maybe you're just simply not ready to give away your assets. You don't trust your children. You don't trust that they're just going to sell it and then kick you out of the house or something like that. So obviously it's not for everyone, because once you sign over that deed to your house, it's done, right? You've given it up. And again, it can't go back, especially after February 16th, because then you're going to get the reassessment. So, obviously a lot for people to think about. Okay, I want to get into the good aspects while we still have some time, but I wanted to make sure, can everyone still hear me okay? Brian, you're good. Good, yeah, okay, I think I'm good. Otherwise, tell me if I'm not. So the good part, so there is some good. Basically what Proposition 19 has done, and what, if you were to read the commercials, all it did was essentially expand some benefits for those 55 and older and disaster victims. So starting April 1st, it's basically an expansion of what we know as Prop 60 and 90, right? So we've always sort of had this in a roundabout way, but there are some differences that clearly are going to benefit some people. So 55 and older or disaster victim, that's the threshold. That's nothing new. That hasn't changed. What's new is that now you can move anywhere in the state. So if you've got a house in Orange County and you want to retire to San Bernardino County or whatever it is, you can absolutely do that. It used to be that the counties could basically opt in or opt out of reciprocating this. And a lot of counties did not. Some did. I think like LA and Orange County, for example, did. But that's kind of all changed over time. And anyway, as of April 1st, you can go anywhere in the state. So it does not matter. The county doesn't want to take you, too bad. They have to. Anywhere in the state. And then you can do it 3 times, up to 3 times. That's new. You used to only be able to do it once. So now you can do it up to 3 times. And that's likely. I mean, people are living longer than ever. So maybe, you at 55, you want to, downsize to that nice beach house or something. And then maybe at 70 or 80, you move somewhere else, so that is a nice benefit. You can do it 3 times versus just the once that you could do it before. And then the property can be of greater value. This is probably the biggest difference. So the old test, if it had to be an equal or lesser value, which actually was 100%, 105%, or 110%, depending on the length of time. But that was tough. Some people would sell a house and you want to downsize, but maybe you want to live by the beach or something like that. And so even though you're getting a smaller house, it may be a whole lot more expensive. So, a lot of people were precluded from taking advantage of the 60 and 90 propositions because the property values just wouldn't mesh. So now this is a definite big deal that it doesn't matter the property value. Now you get a blended rate for anything over the existing property. You don't just get to take your $20,000 property tax bill, buy a $10 million house and transfer it. No. But basically, the amount will transfer dollar for dollar, but everything over that purchase price is going to get the new tax. So if you sell your $2 million house and you buy a $3 million house, you're basically going to get, the $2 million is going to transfer, but then you're going to be taxed on that overage. So if that sort of makes sense. So that's the benefit, and that, that clearly is going to help people. But in my mind, especially with the more urgent deadline of the February, I just view that as the far more pressing issue going on right now that people should be aware of, so that they can, in theory, make their own decisions. And then come April 1st, this will all be new, and clearly people will be able to take advantage of it, and that'll be fun. So that's really it. I kind of wanted to make it short and sweet, and looks like my internet held up, so very happy about that. That's my conclusion. I want to thank everyone so much. I definitely want to take some questions. And before we do that, I'll let you know I do have a blog on it. So it's my website, lucasrealestate.com, Proposition 19. I've got kind of all this as well as some sources on there. You can copy it, but give me attribution. If you feel comfortable writing your own blog, of course, feel free to do that. I do think it's a really important thing to let some of our clients know about. And that's it. So I have my other website here. A lot of people call me with questions. I'd love to answer all of your questions, and we will here. I've got plenty of time this morning. But yesterday I did this presentation. I got like 15 emails, people asking me questions. And as much as I would love to talk to everyone, we're getting a lot of phone calls right now. I charge people is the short answer. So, if you or your family think you'd really benefit from, a 1-hour private Zoom conversation, I do a lot of that. But other than that, I just ask you to kind of stick to my blog, check with CAR Legal, things like that. Maybe in a couple of weeks, I'll have more time and you can call me. But until then, I do have to be respectful of the people that are paying for our time. But we have time this morning. So questions, Brian, any questions out there?